This is one of my favourite cases to teach. In Australia, we all know Hungry Jack's. It's our local version of Burger King, which is based in the USA. For many years, Hungry Jack's was the sole Australian franchise holder for Burger King. They did so well that by the early 1990s, Burger King wanted to enter the Australian market directly. Burger King played dirty. They had a Hungry Jack's insider supplying them with confidential information. They allowed Hungry Jack's to invest in a joint venture with Shell Servos, but made a secret deal with Shell to establish Burger King stores instead. And then there was the development agreement. This contract had been signed in 1990. It required Hungry Jack's to open 4 new stores a year in Queensland, Western Australia and South Australia. Burger King had to give its approval for each new store. In 1995, Burger King informed Hungry Jack's that they would not be approving any new stores in Australia. This meant that Hungry Jack's would technically be in breach of its obligation to open 4 stores a year. It also meant that as Australian cities expanded, Burger King could move into those new territories instead of allowing Hungry Jack's to open the new stores. Now, there's no question that Burger King was allowed to withhold its approval for the new stores. One question for the court, though, was whether the contract included an implied term that they would only exercise that power reasonably and in good faith. So they could withhold approval if there was actually something wrong with the planned new store, but not for other unrelated commercial reasons. Burger King said that no such term should be implied into the contract. The court backed Hungry Jack's. Their Honours said, "We have concluded that Burger King breached its obligations of good faith and reasonableness by its conduct in imposing the third-party freeze and in financially and operationally disapproving Hungry Jack's from further expansion. In reaching that conclusion, we have focused on the conduct of Burger King." The question then arose whether this meant there was a broader obligation of good faith in contract law. Should this be implied in all contracts? Well, no court has ever said so. There was an implied obligation of good faith in this contract, but we don't yet have a broader good faith requirement in Australian contract law.